Шановні колеги, до слова запрошується доктор Райнер Кульмс, доктор юридичних наук, професор Інституту іноземного та міжнародного приватного права імені Макса Планка. Тема доповіді «Значення та перспективи угод про асоціацію між Європейським Союзом та пострадянськими країнами на прикладі України, Грузії, Молдови в контексті імплементації принципів європейського приватного права».
Well, good afternoon, ladies and gentlemen. Let me first of all express my gratitude to the Supreme Court and to the University for hosting me in Kiev. I have to confess this is the first time in Kiev, and I'm really enjoying myself in Kiev. The day before yesterday, I was in Sophia Cathedral and Mikhailevsky Sobor, and yesterday afternoon, I had the privilege of visiting the Lavra. But coming to the Supreme Court today, I have to say that the architectural beauty of the Supreme Court really tops everything. Now, my presentation today is about the association agreement, but what I would like to do is I would like to take a slightly different focus. When we are talking about the association agreement, we are talking about obligations to implement the association agreement. But before we really can start thinking about implementing the association agreement, we have to focus on the institutional arrangements. So for some part of my presentation, I would like to focus on the institutional conditions which are a precondition before you can start implementing the association agreement. I would then like to focus on other international players which also play a decisive role in setting the framework for the implementation of the association agreement. And finally, in the third part of my presentation, I would like to talk about the association implementation reports, both from Moldova, Ukraine, Georgia, but also from countries which are subject to the regime of the stabilization and association agreements, that is mostly countries on the Balkan states. Could I have the next slide, please? When we are talking about the association agreements, we are basically focusing on three principles. One of the principles, the first principle, is one which is closely related to the conditions of running an economy, which refers to the condition of having a free market economy, a sustainable development, and effective multilateralism. And then, and that has occupied some parts of this morning debate, there is a question of what does rule of law mean in a transformation country? What does rule of law mean as to be implemented under the obligations of the association agreement? And that, of course, also raises questions: what constitutes good governance in a transformation country such as Ukraine? Let me just say as an aside, if you look at the texts of the association agreements with Ukraine, Georgia, and Moldova, you will see that the text of the association agreements is not identical. And finally, when it comes to determining the most decisive policy conditions under these agreements, there is, of course, the obligation of fostering the fight or committing itself, the countries, to the fight against corruption, criminal activities, and organized crimes. Now, if you look at these lists of obligations of policy principles which inform the application of the association agreements, you will see that they seem to make sense. But if you take a closer look, you will see that to a certain extent, the intensity with which you apply these principles tends to be mutually exclusive. And I think what tends to be overlooked in today's debate is that before you can start implementing directives as an obligation under the association agreement, you first have to think about the institutional framework for applying the association agreement. If we take an economics perspective of the association agreements, basically we have two parties. The one party is, of course, the rational application seeker, that is the transformation country signing an association agreement with the European Union. And the perspective there is that from the perspective of the accession-seeking country, you do have to engineer compliance with administration agencies. You do have to reform the judiciary. This morning we had presentations on reforming the judiciary. And finally, you also have to prepare the electorate. And then you will find that the implementation of a directive, the transposition, may well be on the national statute book, but there is a gap between what is on the statute book and what actually happens. And to a certain extent, I also would like to reflect on this gap between reality on the statute books and what is really happening in the real world. Now, from the perspective of the EU, being the rational accession provider, the approach the European Union has to take in implementing these association agreements is basically moving from a management approach towards an enforcement approach. When I'm talking about a management approach, I'm basically focusing on the policy of the EU to first introduce an institutional framework, and then once this institutional framework has been transposed, the question turns into how good is the country in enforcing the directives, how good is the country in transposing its obligations under the association agreement. This is economics, but the question is, if you look at the development of post-Soviet countries after 1989, the question is this really an adequate reflection of what is going on in the real world? Could you switch to the next slide, please? When you look at the development of scholarship after 1989, you could say that the first wave of scholarship was almost a bit naive. They thought that once you had introduced markets, efficiency, and laws about private property, the whole economy would be running. But in a way, there is a kind of disconnect. There is a disconnect between the principles and what is happening in the real world. And somehow this disconnect is an extension of what we heard earlier today, is that there is a disconnect between Western legal thinking and Eastern legal thinking. Eastern legal thinking being more positivistic, and Western legal thinking being more liberal. And if you compare that to the scholarship debate, principally the very first wave of scholarship debate was a very optimistic one. On the same hand, if you look at the real problems of those transformation countries, it was also an unrealistic assessment of what was really going on. If you look at the market economy principles, which also inform the association agreements which the European Union has concluded with Ukraine, Georgia, and Moldova, you will see that they are predicated on the assumption that there is individual economic autonomy and there is institutional property as implemented by a property law, and you will see that the state basically is reduced to being a neutral referee between the parties who litigate about a problem. But the question is, does this really reflect the reality in post-Soviet countries? Does the traditional amount of rent-seeking which you have in Western countries, does this also apply to notions of rent-seeking in transformation countries? And if you look at governance structures, does this mean that you have the same governance structure in transformation countries which you would expect in a market economy country of the West, so to speak? Could I have the next slide, please? What I have on my third slide is statistics which were taken by the World Bank in 2000. And the question with the statistics was that in looking at East European countries, both countries, post-Soviet countries, but other countries from Eastern Europe, if you look at those countries, what is the willingness of private enterprises to pay taxes in order to eliminate corruption, crime, or to eliminate overly burdensome regulations? You can't see it, but if you look at the printed form of my slides, you will see that Azerbaijan was a country, for instance, where the willingness to pay taxes to eliminate corruption, crime, and burdensome regulation was most developed. And other countries, including Ukraine, there was a willingness to pay these taxes as well, but the willingness was less intense as in Azerbaijan, so to speak. Now, there is a basic assumption behind this slide and behind this graph, I think, which is rather telling. And this basic assumption is that obviously there is an awareness that in order to do business, you have to pay certain taxes. The taxes I'm going to talk about in a moment, of course, are taxes which are due to state capture. And there is a feeling in those countries that in order to do business, you have to pay money or you have to invest, but the money which is invested doesn't really go to the business, but goes to other sources, so to speak, to other recipients. And the idea is that it might be cheaper to pay taxes to the state, to have a rule of law, to have proper governance, instead of paying money to other recipients. Could you move to the next slide, please? Now, when we normally talk about rent seeking, we are thinking of the state extracting rents for the exclusive benefit of politicians and bureaucrats. If you look at the rent-seeking model in post-Soviet countries, at least for the initial transformation period, you will see that there is a number of individuals or individual firms which manipulate the formation of policy, and they take a strong influence on emerging rules so that the rules will be construed and the rules will be implemented for their own purposes. And this is the conditions I'm talking about when I'm talking about setting the right framework for assuring the success of the association agreements and for assuring the success of the principles I've talked about on my second slide. If you look at the international players, you will see that the European Union, under the association agreements, is not the only international player who sets the framework for creating a market economy, for creating good governance, and for creating conditions which eliminate corruption, crime, and burdensome regulations. Excuse me. If you look at the policies by the IMF, the International Monetary Fund, the European Bank for Regional Development, and the EU Commission, you will see that there is an indication that economic reforms should be implemented. But if you take a closer look at the policy statements from these institutions, you will see that there is a certain priority agenda which all those three institutions implement. And incidentally, what is interesting is that if you take a closer look at these policy statements, you will see that they do foster competition, but there is also a tendency to support small and medium-sized companies as a mechanism to establish a counterbalance to the large, powerful players. Could you move to the next slide, please? Speaking about one of the major players, and one of the players which became active even before the European Union thought of negotiating association agreements, there is the International Monetary Fund, which with its credit facilities, and as part of these conditions of the credit facilities, whether it is the extended fund facility or whether it is a standby arrangement, there is always the obligation of the recipient country to issue certain policy undertakings in order to create a framework for a well-functioning market economy. Just to cite the most recent letter of intent and the memorandum of understanding, which has been issued by Ukraine on the 2nd of March of this year, there is an explicit undertaking by the government of Ukraine to improve the banking sector, to introduce a regime for restructuring corporate debt, and to ameliorate the protection of creditors' rights, and to introduce legislation for security markets. If you look at the standby arrangements, that is the Ukrainian standby arrangements with the International Monetary Fund, you will see that again, the major focus of the obligations of the Ukrainian government was financial sector reforms and the supervision of banks. There is a certain overlap with the undertakings given by the Georgian government. They asked for an extended fund facility from 2017 to 2020, and that basically focused on an economic reform program. The same holds true, for instance, for Moldova. For Moldova, there is an international credit from 2017 to 2019, and last year in October, the Moldovan government undertook to police breaches of banking law and to update the regulatory and supervisory framework and to monitor state-owned enterprises. Now this is the policy approach, but the question then is, how does this harmonize, can this be harmonized with policy constraints under domestic national law? Could you move to the next slide, please? One more, please. What I'm referring to now is, I'm referring first to the financial assistance requirements, which are under the association agreements. There is a financial assistance agreement requirement under Article 383 of the agreement between the EU and Georgia. The same holds true with respect to the agreement between Moldova and the European Union, and it is a policy of directing funds for the implementation of certain policy principles. In the case of Georgia, it is focused on improving the competitiveness of the private sectors and of converging of Georgian law with EU law. With respect to Moldova, it is an obligation to divert funds for the improvement of the investment climate, but also for improving the quality of the judiciary and the rule of law. If you compare these two provisions applicable to Georgia and Moldova with the financial assistance provision between Ukraine and the EU, you will see that seemingly the pledge of the European Commission to divert funds to Ukraine seems to be less extensive. However, if you take a closer look at the strategy of the European Bank for Regional Development, you will see that they are developing projects to support legal reform. They are also developing projects to support the private sector in doing business. Now, the next slide is slide 9. And the perspective of the slide is slightly different. So far, I've been talking about international arrangements binding the transformation countries to harmonize their policies with what the international agreements say. But if you look at the wordings of the policy of these association agreements, you will see that these association agreements are not directly applicable. But if you look at the economic impact of these association agreements, you will see that they have a fundamental impact. And of course, there is a question, how can the policy impact of these association agreements, how can this be harmonized with principles of democracy? And there is an attempt under the association agreements with Ukraine, Moldova, and Georgia to balance the interest of the association agreements to transpose the principles of the association agreements with notions of democracy and with reactions people might have in the transformation countries when it comes to transposing directives under the obligations of the association agreement. These three agreements provide for the establishment of a parliamentary association committee, which is a committee with representatives from both the European Parliament and the respective parliaments of Ukraine, Georgia, and Moldova. And the interesting thing is that these association committees are entitled to issue recommendations to the Association Council. The Association Council being the council which checks the degree of implementation of the obligations under the association agreements. And it's interesting to see, if you look at the recommendations which so far have been issued by the parliamentary association committees, you will see that they tend to reinforce the obligation of national governments to implement what the association agreements say. And sometimes it seems to me that if there's controversy on a certain issue in one of the transformation countries, the policy these committees is to reinforce and to stabilize the politics of the national decision makers. Now, this so far has been the institutional framework. What I would like to do now is to talk briefly about the implementation reports. And if you think of my second slide of the rational decision maker moving from a management approach towards an enforcement approach, I'm now focusing on the enforcement approach, and I'm trying to reflect on what has been done so far and what still needs to be done under the association agreement. There is, under the association agreement with Georgia, there is an obligation that there is the statement that tariffs have been removed, that trade-related law have been approximated with European Union law, and there is also an extensive chapter on the association report from November 2016, saying that transparency has been improved, and so has been the allocation of cases and the transparency of how cases are allotted from one judge to the next judge. Georgia is an interesting case because if you look very closely at the implementation reports, you will see that the implementation reports focus both on the creation of the institutional framework, but they also focus on policing the transposition of individual policies under the association agreement. And here I'm just citing the consumer protection provisions of the association agreement. Ukraine, the implementation report of Ukraine from December last year still concentrates very much on creating the institutional framework for transposing the obligations under the association agreement. So there is a reference to the anti-corruption measures, there is a reference to improving public procurement, and there is a very basic reference to introducing a competition law framework which is compatible and comparable with the rules on state aids and competition under the Treaty for the Function of the European Union. And finally, there is a reference to the Justice Sector Reform Report, but I think that has been discussed by previous speakers. Now, speaking about Moldova, again, you will see that Moldova, the implementation strategy towards Moldova is a mix between creating the institutional framework and for policing the transposition of institutional and special policies. So there is the admonishment to consolidate the rule of law. Again, there is a reference to the quality of the justice system, making a specific reference to the specialization of judges and to have a case management system which distributes the amount of work evenly among the judges. But there is also a reference to specific policies, and this refers to an obligation to modernize Moldova's labor code, to do something about labor legislation, and to develop financial services. And although there is a competition council in Moldova which oversees the transposition of the obligations under the association agreement, there still is the feeling of the European Commission that something needs to be done in order to advance the implementation of policies on competition. Now, to conclude, let me give a brief overview of what is happening in other countries in Eastern Europe, the West Balkan countries, where they have specific stabilization and association agreements. There, the enforcement policy is much more on specific fields of law, such as consumer protection law, competition law, and also the organization of justice. To conclude, with respect to creating the framework for transposing the obligations under the various association agreements, it seems to me that with respect to Ukraine, Georgia, and Moldova, we are somehow halfway between creating the institutional framework and for transposing specific policies, and this creates a special obligation both for the Commission and for the national governments to approach the various steps of transposition of the association agreements with a certain degree of delicacy. Thank you very much indeed.
Дякую доктору Кульмсу за цікавий виступ. Звертаю увагу. Для мене особливо було дійсно звертати увагу на такий ціннісно орієнтований підхід, а з іншого боку на елементи свого роду економічного аналізу права, що для української практики і доктрини є досить актуальним.